cell phones and other electronic devices that might emit some noise during oral arguments. All rise. The Court of Appeals Division 1 is now in session.
Morning. Please be seated. Joe, do you have the sign-in sheet? This is the time set for oral argument in the case of Maynard versus Raymond James IRA St. George versus Jensen, our civil number 12-0663. Each side will have 20 minutes within which to present their argument here this morning. We have read the briefs. We're familiar with the record. We have, in fact, conferenced the case this morning. So please keep that in mind as you make your arguments this morning. We're familiar with the issues and the record. We are recording these proceedings, both audio and digital video. So as you approach the podium, please identify yourselves and your client for us, and understand that at some point when the recording will be available on our website for viewing, if that's what you're interested in. With that, you may proceed, please.
Thank you. Good morning, Your Honors. My name is Larry Hattie. I represent St. George Antiochian Orthodox Church, along with my co-counsel Scott Ferris. I also want to introduce representatives of the church here today, being the parish priest, Father Christopher Salemi, also the president, Christina Saig, and the past president, John Karachi. Your Honor, this case involves the entry of an order which has effectively nullified and effectively have abrogated the statutes which express the public policy objectives set forth by the Arizona legislature in implementing an exclusive procedure for the establishment and transfer of non-probate assets. The reason for this statute was set forth in 1994, when at that point in time the legislature determined that the statutes, the individuals who were conducting non-probate assets were in fact being subjected to probate proceedings, because people would come from nowhere and say, we're challenging the intent, and that was an issue that the legislature felt should not be addressed. So what the legislature did, they entered into the statutes, which are 6101 through 6127, and specifically the statute that's in question is 14-6214 or 42-614 1642.
Let me interrupt you, Mr. Hattie, because I know where you're going, and I think we all do. And let's assume, for the sake of argument, that intent under the probate code isn't relevant here. But let's also assume that, as you've noted, this is a non-probate asset that has to be transferred consistently with the terms of the contract, which is the IRA agreement. So if we're looking at contract principles, and I'm saying if, we determine that the language of the IRA beneficiary designation is susceptible of the construction proffered by the foundation, then Mr. Maynard's intent could be relevant.
I don't agree that, well, I don't agree, Your Honor. I believe that as a result of the statute, it has now been determined that the intent is based on the language that is used. So
Intent under the probate code, again, I'm giving you for the sake of a hypothetical, but under contract principles, you say that this is a contract that has to be interpreted according to contract terms. Intent can be relevant there, but moreover, and let me add to what I just said, the cases you cite, like Jordan, when you have a payable on death account, clearly you cannot offer intent to vary the terms of the express payable on death designation. But those cases do not stand for the proposition, as I read them, that if the designation of the beneficiary itself is ambiguous, then intent is irrelevant. Those were cases where, say, an ex-husband didn't change his wife on the account before he died, but he meant to. Well, clearly his intent couldn't be introduced to contradict the clear naming of her. But if we get to a point where we think the beneficiary designation itself is ambiguous, none of the cases you've cited, as I read them, would tell us we can't consider intent.
Okay, yeah, I'm sorry, and I agree, Your Honor, that if in fact there was a determination that there was an ambiguity, if there is an ambiguity, then yes, but in this particular situation, there's clearly no ambiguity. The statutes, we can't use parole evidence because parole evidence only deals with situations where, or do not deal with situations where you're actually amending and changing the terms. And this is what the problem is when Mr. Maynard executed the original document, he and Mr. Joe stated that the purpose of the IRA was to designate a beneficiary from the list of charitable organizations that are contained in the Survivors Trust. And that the document, the argument ended up with the trial court and also the PR in its original brief taking that language and converting it over to a beneficiary residuary, a residuary beneficiary, which is totally different. And
but let me suggest that it's not as clear as you suggest. Let's talk about the $100,000 grant. No question about that. St. George Antiochian Orthodox Church of Phoenix, Arizona. And had the IRA beneficiary designation said that, none of us would be here. But it reads, the charitable organizations as called out in the Fenton Lee Maynard Survivors Trust, UAD 61-2005. There is no Fenton Lee Maynard Survivors Trust. There is no document labeled that. So that right away creates some question. Charitable organizations used in the plural. It seems to me that there is some question about what that beneficiary designation means.
well, I asked Mr. Joe. I asked him those very same questions. There's only one individual who's still alive who was involved in that discussion on February 17, 2009, when Mr. Joe and Mr. Maynard met for the purpose of executing 3 different accounts, one of which was the what we call the Maynard IRA. And in that account, he specifically said that as pointed out, that the Fenton Maynard was the trust or was the owner of the account, and it was the charitable organizations as called out within the Maynard Survivors Trust. So, I mean, the fact that there's not a separate document, they knew what they were talking about, and they had Mr. Maynard specifically sign all of the documents. So I asked Mr. Joe, just for the very reason to say, I took him through specifically what he considered to be the Survivors Trust. And I got him to admit what was in the what pages constitute the Survivors Trust, paragraph 2.6. And then I asked him, I said, I'm going to, after determining that, I said, tell me which charitable organizations are identified in that trust, in the Survivors Trust. And he said it indicates in this case here that the St. George Orthodox Church. And that's the only charity, isn't it, called out or identified, as you say? That was my question back to him. And he said, in this document, yes. So he immediately admitted that the only charitable organization that is referenced in the Survivors Trust is St. George. Now, I noted that also at the bottom of the Survivors Trust, or the paragraph 2.6, which again is been considered as the Survivors Trust, I pointed out to him the language at the bottom, because in my opinion that is the crux of where the court is erroneous and the PR's position is erroneous. It says at the bottom that the rest of any Survivors Trust property shall be allocated to the charitable trust held under Article 8. In other words, any funds that are going to go under the Survivors Trust, and I would point out that the first entity listed is St. George. Immediately after that, it names a couple of others. Any funds that are left there then go to Article 8. There is nothing within that document which identifies a charitable organization, but I asked him about it. And again, I said, in Exhibit 14, the Maynard IRA, you did not designate the charitable trust as a beneficiary, correct? And his answer was, by Mr. Joe, no. And then I said, I mean, is that correct? And his answer was, that is correct. So we now have the individual who wrote the document, the individual who met with Mr. Maynard, pointing out that there's only one charitable organization that's named and identified in the Survivors Trust, and that is St. George. Now also, I would point out that there were two other accounts that were presented at the same time. Those two other accounts were both signed same time by Mr. Maynard. And what they were accounts that were trust assets and that were leaving as beneficiary the Survivors Trust. So in that situation, it was totally different than the third one. Or the PR and the court decision seems to think that the three accounts, or the account that were that from the third account is the same as the others, and it's not. So there's no question but that the language that we're looking for is exactly what we have indicated is supposed to be. It is not ambiguous. There is no parole evidence that's needed. Now, the other point that I wanted to raise was that when the I'm sorry, I'm losing my eyesight here. I can't, I'm not reading what I'm looking at here, but what I wanted to point out was that the PR, in its last pleading that was filed, admitted that the language of the IRA prevails over the language that is contained in the well, what I'm getting at, I'm sorry, I can't see. I'm right now, I'm not being able to see at all, so I'm having a difficult time getting through this. If, with your honest permission, may I reserve my last 7 minutes?
You may, counsel. Mr. Brew.
My name is Lindsay Brew. I represent the University of Arizona Foundation, party and interest in this case. Mindful of the admonition that the court has already viewed this matter, I will try to restrict my arguments to the two key points. One, first.
Can I ask you my burning question, which is similar to what I asked Mr. Hattie? Why is the Raymond James IRA beneficiary designation susceptible of differing interpretations? And specifically, why isn't the reference to the survivors' trust dispositive?
Well, as you correctly pointed out, Judge Downey, in questioning Mr. Hattie, there is no document labeled the Survivors Trust. There are provisions in the 2005 restatement of the Fenton and Margaret Maynard Trust that apply when Margaret dies first. And those provisions say that you pay $100,000 to the church, which was done. You pay, I think it's $1.2 million to the nephew, and there's some other things that go on. And then the rest of the trust, the rest of the funds, go under paragraph 8. And paragraph 8 is the only provision in the restated trust that actually refers to charitable organizations.
By name, but calling them
By
charities.
those terms. There's no, the term charitable, there's no descriptor of the church in the listing. It's just the church. It's not called out as a charitable organization. The charitable organizations are all listed in paragraph 8, and they were at that time the American Heart. I think they. Well, I don't think the court needs to know who they were, but I can tell you real quick. They were the American Heart Association, the American Cancer Association, the Arizona Kidney Foundation, and the Salvation Army, and the T-Gen Foundation. That was a new addition in the 2005 version. The original trust had the Boys and Girls Club in there instead.
So just to make sure I understand, as a threshold matter, you're saying this language, the Fenton Lee Maynard Survivors Trust UAD 61-2005, no such trust UAD 61-2005 exists, does it?
There is
It is subsumed within the broad trust.
There is a trust agreement that was done in 2001, which was amended and restated in 2005. And that's what the 2005 refers to as the amended and restated. You know, technically, once you restate the trust, you never have to go back.
But if a person were to look for the Fenton Lee Maynard Survivors Trust UAD 61-2005, there is no such animal.
There is no document by that name. There is a provision called Survivors. I believe it's called.
Survivors Trust in paragraph or Article 2.
Article
and
2,
Charitable
Survivors
Trust.
Trust, and paragraph 2.6, distribute Survivors Trust if Fenton Lee Maynard is the surviving grantor. And the last sentence of that is that the rest of the Survivors Trust property shall go to the Charitable Trust. That's part. You have to read any type of document that has various pieces. You have to read it as a whole to determine what happens to the money. And that's why the reference to charitable organizations in the IRA, new form, is there, because even though he was under tremendous pressure because of the battle he was going on with his former employer for the clients, and he was rushed and he probably didn't have the documents in front of him when he did this, he remembered charitable organizations as a term of art used in Section 8, and he used that term.
And what are we to make of Mr. Joe's testimony that Mr. Hattie just discussed, that no charity besides the church was listed in paragraph 2.6?
Mr. Hattie did a very good job of pointing to the document and getting Mr. Joe to admit that there's no charity other than the church listed specifically in section 2.6. That's what he did. And that doesn't mean that they're not listed in the trust. They're just not listed in 2.6 by name. And Mr. Joe testified quite clearly that he was the one who drafted the language in the IRA, that he was trying to replicate the language from the Smith-Barney IRA, which he wouldn't have had access to because he was out the door and they're not allowed to take the documents with him. And he is doing the best he can under the pressures of the circumstances, and he intended to not change the IRA beneficiary from Smith-Barney. And he never discussed changing the IRA Smith beneficiary with Fenton Maynard. And in fact, he said, he said, we never talked about changing the beneficiary at all. He never talked about changing the beneficiary. No, he did not. No, excuse me. That's my question. Was he never talked about changing the beneficiary at all? Answer, no. Question, was it your understanding at the time in February 2009 by that language that he was agreeing to that he was changing the beneficiary? No, we thought it was the same.
Well, it seems to me if you get to the question of intent, the record only supports one interpretation of intent.
Right.
So I know where you're arguing intent, but the more problematic threshold issue for me is whether the trial court properly considered extrinsic evidence, including intent.
Then you have to go back to the Taylor versus State Farm case. And that says that whether or not there is a ambiguity is not to be determined from the four corners of the document. It's not the judge's idea of what the documents say that counts. It's the party's idea of what the documents say. So in order to determine whether or not there's an ambiguity, you have to listen to the parole evidence.
If it's reasonably susceptible to the interpretation being proper.
Right. You listen to it, you listen to the parole evidence, which was done below, and after listening to it, you make a determination whether the language is reasonably susceptible of interpretation as the parole evidence suggested it was to be.
Okay, I'm going to differ with you a little bit because I think the analysis is the interpretation being proffered reasonably susceptible? And if it is, then you consider the evidence. And so that's why I'm trying to refocus you. I'm looking at Taylor. In interpreting a contract, a court must determine whether the contract language is, quote, reasonably susceptible to the interpretation asserted, which is a question of law for the court. If so, the court may consider the proffered evidence on the issue of the party's intent. At least that's how I understand the Taylor framework.
I don't think that's correct.
No?
I think the better rule is that the judge first considered the offered evidence. You first consider it, and after you've considered the evidence, in light of that evidence, you find that if the contract language is reasonably susceptible to the interpretation asserted by its proponents.
And then if the court concludes that the evidence does not vary or contradict the meaning of the written words, it may be considered in determining the party's intended meaning.
Right. And in this case, it is the meaning of the written word itself which the parole evidence was tendered to establish. And this gets me back. I don't want to dwell on this too much, but this if, for example, the parties use language that is mutually intended to have a special meaning, and that meaning is proved by credible evidence, a court is obligated to enforce the agreement according to the party's intent, even if the language ordinarily might mean something different.
And the contract parties here are Raymond James through Mr. Joe and Mr. Maynard.
Right, and both, and Raymond Mr. Joe testified as to the intent of both parties. And that wasn't objected to, and it was admitted and argued below.
So what is the language that you say the parties attach special meaning to that is proved or supported by the...
Charitable organizations
Plural.
called out in the trust. Viewing the trust as a whole, the charitable organizations can only be the charitable organizations listed in Section 8. And I want to also, and I don't want to go too far afield here, but I think you don't necessarily have to ever get to that point, because I believe that the church is wrong on its claim that 1462:13 precludes the 2009 trust amendment from changing the issue of, the beneficiary in effect that gets the money under the IRA. The church has argued that, let's put it this way, backtrack a little bit. The the June 2009 trust amendment did away with the last sentence of Section 2.6 and substituted a provision that the remainder goes to the foundation for the benefit of the Excellence in Cancer Research endowment founded in the name of the Maynards. That document was in effect at the time that Fenton Maynard died. The IRA agreement at the time Fenton Maynard died said that the IRA was to be paid out to the charitable organizations as called out in the Survivors Trust. The Survivors Trust, at the time Maynard died, said $100,000 to the church and the rest to the foundation. Since the church has gotten its $100,000, the reasonable interpretation of that language is that the IRA is part of the rest that goes to the foundation. Mr. Hattie argues that that amendment is invalid because it wasn't delivered to the IRA custodian during Mr. Maynard's life. And he cites 1462:13 for that proposition. That statute simply doesn't apply.
Well, let me ask you this. I probably should ask Mr. Hattie this, but for the sake of argument, if we agreed with the trial court that the church was not a beneficiary of the IRA, do we even reach those arguments? Because even if the amendment was ineffective, all it does is reinstate the 5 charities. It doesn't put St. George in any status to. Don't you make
If you determine that the language of the IRA never included the church, you don't you don't necessarily have to deal with the June 2009 amendment to the trust. My argument is that even if you have some question about whether the St. George was a charitable organization as called out in the IRA in the trust, that issue is mooted by the June amendment to the trust, because the June amendment to the trust specifies that the foundation gets the rest beyond the $100,000 that the church has already got. And I believe that's a valid amendment simply because it didn't alter either the type of account or the payment provisions in the IRA. Those are the two things that require a written notice to be delivered to the custodian during the life of the account owner.
So your position is the beneficiary designation never changed. The documents that you would consult to determine at the time of death who the actual beneficiaries were
Right,
is
yeah,
not
the
the proper
benefit,
focus.
yeah, that's the argument. The beneficiary designation in the IRA itself never changed, and that was specifically how the court below ruled. So the issue then comes down to really either on the basis of that the June Amendment is valid, or on the basis that the church was never part of the IRA beneficiary designation, they should lose and we should win. I want to say, I have 4 minutes left. There's one issue I want to address because I didn't get to brief it because it was raised in the first time in the answering brief, and that is the attorney's fees. This is an issue arising out of contract. We have requested attorney's fees in this court. The church objects to that request on the grounds that the trial court below denied our request for attorney's fees, and we haven't appealed that order, and it's therefore res judicata. The trial court denied our request for attorney's fees in the trial court pursuant to a rule of civil procedure applicable to the trial court that says we had to put that request in our pleading. That is the answer to the petition. We did not do that, therefore he ruled we weren't entitled to it. Rule 54G, which he relied on, doesn't apply in this court. This court has its own rule, 21C, and that says the request for attorney's fees has to be in the brief, and that's where we put it. Thank you.
Mr. Hattie.
Thank you, Your Honor. The problem is the confusion that exists in the PRs and the foundation's minds when they cannot distinguish between trust funds, testamentary funds, and non-trust or non-probate funds. When Mr. Brew talks about 1462.13, he talks as if the funds are only testamentary. And in fact, we don't care anything about what's in the Third Amendment. It doesn't involve any of the funds that are being transferred pursuant to the IRA. The IRA are non-testamentary funds, and that's the reason there's a distinction. Now, also, yes, we have argued that the Third Amendment is not valid. We've said that because it was not transferred to Raymond James. Despite what anybody says, it was not transferred to Raymond James until after Fenton Maynard's death. And according to that statute, it is not a valid document. Saying that the beneficiary designation itself satisfies that statute just makes no sense, because it doesn't. It doesn't identify anything. All we know is that the foundation, as a result of the Third Amendment, now becomes the residuary beneficiary of the trust funds. And we have no objection to that. And it's gotten them $5 million already. So there's no problem with that. It's this other fund that's sitting out here that's a part of the IRA that they don't seem to understand also passes to whoever is designated as a charitable organization. St. George, if St. George was not a true beneficiary under the original IRA, why weren't they pulled out in the Third Amendment? They were left in the Third Amendment.
Let me clarify my understanding of what you just said. And this is just hypothetical. If we were to affirm the trial court's ruling that St. George was not an IRA beneficiary, do we reach this issue you're raising about the Third Amendment? Because it seems to me you couldn't benefit even if you're right.
Well, I'm not...
Well, I know you disagree with that if part of it, but if that were the decision, then whether the Third Amendment's valid or not, wouldn't that only benefit the 5 that were cut out? It wouldn't benefit your client even if you're correct legally, would it?
Well, if you were going to do that, then let's talk about two separate documents. We're talking about the initial IRA as it became effective on February 17th, and if, in fact, the trial court says that St. George is not a beneficiary at that time, contrary to everything that Mr. Joe said, then we're talking about there was an amendment to that document, to the trust that's referenced in the original IRA, and that amendment put St. George back in.
How?
Just simply by the fact that it was there. I mean, it's number one. When Fenton Maynard did the Third Amendment, he's the only one of the whole group on that Third Amendment that knew about the IRA, and vice versa. Neither Raymond James nor Mr. Joe knew about the Third Amendment until after the death. So if Mr. Maynard, in fact, then he's the only one that was in both parts. If he thought that he wanted to change St. George, or if St. George was not going to be it, then he would not have added St. George to the Third Amendment. And there St. George is number one right away. And
But for the $100,000 specific grant.
totally irrelevant to what we're doing, though. The $100,000 is totally irrelevant.
Yeah, but I'm just trying to make sure, because I've looked at that Third Amendment, I just want to make sure I'm understanding what you're saying. There's nothing new in the Third Amendment about St. George. St. George appears in that just as it had in the Second Amendment.
Correct.
Okay.
I mean, now I think they just changed a few individuals, and St. George was kept in, and the only real change was that the foundation became the residuary beneficiary under the terms of the Survivors Trust. On the Survivors Trust, one of the initial points that Mr. Brew was asked about, there may not be a document that's called a Survivors Trust, but it springs into existence upon the death of Mrs. Maynard, and that's contemplated by the language of that document. So I believe there's no question about what that is referencing. Now, I'm still having difficulty understanding how we can find any kind of an ambiguity in the language when we have the individual, Mr. Joe, specifically state that St. George is a charitable organization, and St. George is the only charitable organization that's identified in that IRA beneficiary designation.
What about Mr. Brew's discussion of Taylor versus State Farm, that if the contracting parties used a term with a specific meaning, then the court needs to enforce that commonly understood meaning? And Mr. Joe, yes, did say that St. George is the only charity in paragraph 2.6, but he also very clearly stated that the intent was never to make St. George the beneficiary.
But the point is that the foundation, neither nor the PR or at that point in time the counsel for the PR, nobody knew about the IRA, and it's Mr. Joe specifically stated it. I don't understand how Raymond James could come into it, because Mr. Joe specifically said, I never even told our legal counsel about the drafting of this IRA. I never even told them about the fact that Mr. Maynard signed a document that said that the beneficiaries are the charitable organizations that are listed there. So I don't think we have any type of an agreement. There's nothing in the record for that. In fact, there were several things that I thought were said and I don't think are part of the record. I believe that in the last document that was filed by the PR, finally, after going through this entire proceeding, filing the initial petition for instructions, which if your honors will look at, you will see that every single statutory section references something within chapters 1 to 4 of the revised probate code. Sections that are not applicable to the discussion that and the decision that needs to be made here. And we need to to take that into consideration also. Finally, with respect to the attorney's fees, we have addressed it. We've gone far beyond the just the 34101. I can state that we did not request attorney's fees because we did not feel that they were appropriate. We, in all good faith, did our research and could not find any legal basis for obtaining the attorney's fees. And furthermore, that quite frankly, I mean, we're a charitable organization. That's the unfortunate part of this whole litigation, is it's between two charitable organizations.
Thank you, Mr. Hattie.
Thank you.
We appreciate the briefs filed and the arguments of counsel here today. We're going to take this matter under advisement. We will issue a written decision in due course. We stand adjourned. Thank you.